Hello everyone and welcome to our webinar today. I am Dr. Colin King, Director of the Centre for Financial Law, Regulation and Compliance at the Institute of Advanced Legal Studies, and we are delighted to host this webinar in collaboration with the Law Commission. This is one of 9 webinars organised as part of the consultation on the confiscation regime, and the Commission should be applauded for these events. We have a great lineup to talk about specific aspects of POCA in practice over the coming hour or so, with speakers from the Law Commission, HMCTS, 33 Chancery Lane, Drystone Chambers and Thompson & Co solicitors. And thanks to all of our speakers for taking time out of their busy schedules, and thanks in particular to my colleague Dali Sarkos, the events manager at IALS, for all her work on making this webinar possible. So part 3 of the consultation paper is concerned with preparing for the confiscation hearing, which is what we focus on today. I think this is a very timely consultation, because of course many of our attendees will know the confiscation regime has received a lot of critical attention in recent years, including from the Public Accounts Committee, the National Audit Office, and in the media. So this consultation paper, I think all 744 pages, offers an opportunity to take a step back and reflect on what has happened and how the law has evolved since POCA was enacted in 2002. And clearly there are issues in practice, and the consultation does say at one point that the current regime is overly complex and creates traps for the unwary. So our structure for the webinar is as follows. First, the Criminal Law Commissioner, Professor Penny Lewis, will say a few words. Then David Allen from the Commission will give an overview of some chapters of the consultation, namely chapters 6 through to 10. Then we will have a 5-minute response from our 4 respondents. Fiona Jackson will give her thoughts on Chapter 6, postponement. Debbie Nocton will comment on Chapter 7, timetabling and case management. Barnaby Hone will comment on Chapter 8, early resolution of confiscation. And then Mutahir Ahmed will comment on Chapter 10, forum. And we will then open up discussion for Q&A. Before I introduce the speakers, I just pass over to Debbie Nocton for a minute. Debbie, you wanted to come into this point?
I did. Thanks, Colin. I just wanted everybody who's at the event today, for their understanding, I just wanted to explain that I am disabled. I've got a couple of disabilities. I am hard of hearing, so I always wear earphones, and I have a neurological disorder called dystonia. That means that my head sticks to the left sometimes, and I also suffer from tremors. So I have to do all the things you're not supposed to do at an event such as this. I have to cross my arms or touch my face to try and stop that. So my fellow panellists know that if my head is shaking, it's not because I'm disagreeing with them. And if I cross my arms or something like that, I'm not being defensive. But I just wanted everybody who's at the event today to know that and to ask their understanding. Thanks, Colin.
Thanks very much, Debbie. And I will now pass over to Professor Penny Lewis. Penny took up her current position as Criminal Law Commissioner in January of this year, and it clearly has been a busy year. Since taking up her role, she's been active in this consultation paper on confiscation, and also another recently released consultation paper on hate crime legislation. Penny is also a Professor of Law at King's College London, with particular research interests in the overlap between criminal law and medicine. So we are delighted to have you with us today, Penny, and to hear more about the Commission's work in this area. Over to you.
Thanks very much, Colin. That's actually just 2 of the 5 publications we've published in the last 6 weeks. We also have another consultation running on harmful online communications. And yesterday we published a report on search warrants. So please do take a look at our website if you're interested in any of those, and also our report on the protection of official data under the Official Secrets Acts, which we published at the beginning of September. I'd like to welcome everyone to this consultation meeting for our consultation paper on Part 2 of the Proceeds of Crime Act 2002, which, as I'm sure you know, governs the confiscation of the proceeds of crime by the state after a defendant's conviction. I'd very much like to thank the Institute of Advanced Legal Studies for arranging this meeting. I have spent myself many, many hours in the Institute of Advanced Legal Studies library, where I've been very much enriched by the comparative law collection. We're really looking forward to hearing your views on some of our provisional proposals today. I'm just going to very briefly give you a little bit of background to our review and then introduce my colleague, who's going to give you some more detail about the chapters that we're looking at today. So the Law Commission commenced this review in 2018. The project is sponsored by the Home Office, and the terms of reference really require us to focus on simplification, clarification, and modernization of the post-conviction confiscation regime. One of the motivating factors that prompted this review was the perception that the current confiscation regime is ineffective, it's inefficient, and it's overly complex. And the headline figure of an existing £2 billion outstanding confiscation debt is often quoted in this context. During the drafting of our consultation paper, we've engaged fairly extensively with stakeholders from across the criminal justice system. And that perception of the system has been reinforced by those meetings that we've had with stakeholders. We've therefore developed provisional proposals which aim to improve the process by which confiscation orders are made, ensure the fairness of the confiscation regime, both to defendants and to victims, and to optimize the enforcement of confiscation orders. The way the consultation paper is structured is that it mirrors the way a confiscation matter progresses through the criminal justice system. So we start with the kind of case management processes that occur prior to a confiscation hearing, and we conclude with ways to maximize the capacity for enforcement action through effective management of defendants' assets. We've suggested reforms to encourage the effective use of powers to prevent assets from being dissipated before a confiscation order is made, to ensure that when confiscations are made, they realistically reflect what a defendant gained from crime, and to improve the enforcement of confiscation orders. To briefly introduce the team from the Law Commission, aside from me, we have David Allen, who is one of the lawyers who's working on the project. And Elizabeth Hartley is also joining us. She's one of the research assistants who's working on the project, and she'll be taking a note throughout the event. David is going to briefly present, as Colin said, 4 of the chapters in the early part of the consultation paper: postponement, timetabling and case management, what we call EROC, or early resolution of confiscation, and forum. And then we're very pleased to have a response from the 4 panelists that Colin mentioned, who are each going to comment on one of the chapters. This is one of a series of events that we're holding until the consultation period closes on the 18th of December. We very much hope that, having had an opportunity to consider our provisional proposals, you may wish to take part in other events which will look at other aspects of the paper in more detail. We also strongly encourage you to formally respond to our consultation using the consultation survey tool. You may already know that there's both a summary version of the consultation paper, which is a much more manageable 40 or so pages, and the much longer 700 or so pages full version. You're welcome to engage with parts of the full version, to engage with the summary, which has its own set of more broad summary consultation questions, or mix and match, whatever suits you and your particular interests. But please do respond. It's only through consultation responses that the Law Commission can produce robust recommendations to government and to Parliament. And we'll have a much greater chance of being able to have our recommendations implemented if we can demonstrate that they're based on a very strong consultation response and hopefully on some consensus. It's possible to find all of this information, the summary, the consultation paper, links to the survey tools, and contact details for the project team, and information about future events on our confiscation webpage. The fastest way to get there, rather than me giving you a complicated link, is to Google Law Commission Confiscation, and then you will go straight there. I'd like to thank Colin very much for chairing this event. I have to apologize. I'm going to have to duck out before the end because I have another meeting to attend, but I'm very much hoping to be able to hear most of the discussion. And now, without further ado, I will hand over to David Allen. Thank you.
Thank you, Penny. Hello, everyone, and thank you all for attending today. I'm here to talk about chapters 6 to 10 of our consultation paper, which concern the process of making a confiscation order. I've only got 10 minutes to get through 4, or in fact 5 chapters, because I'm going to sneak in a bonus chapter. So I've summarised our proposals on slides, accessible versions of which will be available online. So I'm not going to read out what is on the screen. I'm just going to pick out 1 or 2 proposals from each chapter to talk about. So let's start. So the first chapter that I'm going to talk about is chapter 6, postponement. Now this chapter concerns the initial period that commonly occurs between sentencing and a confiscation hearing. Looking at proposal 2 on the slide, permitting other financial orders to be made before a confiscation order. Well, currently such orders are prohibited where confiscation proceedings are to follow, to the not uncommon exasperation of Crown Court judges and advocates. It seems common sense to make a forfeiture order of seized drugs on the date of conviction or sentencing, instead of waiting perhaps months until confiscation, when such matters may be overlooked. Now, since the cases of Crown against Kakad and Crown against Guraj, it is clear that the making of such orders, although in breach of the Act, does not necessarily preclude a later confiscation order, unless there is an incurable unfairness. And our proposal reflects that position. But we also propose that such orders, if made, be taken account of when a confiscation order is ultimately made. Again, that mirrors the current position, that a defendant's available assets do not include property which is not free because it has been forfeited, or obligations on the defendant which have priority, such as to pay a pre-existing compensation order. However, our proposals would give the court the explicit power to make a compensation order in the same case without waiting for confiscation proceedings to conclude. Ideally, we suggest a scheme whereby outstanding compensation orders at the time of confiscation would benefit from the increased enforcement powers for confiscation orders. Well, turning to proposal 4 on that slide. Now, the title of this chapter is postponement, but our suggestion is that the whole regime of postponements, which has had an unhappy history, be replaced by a simple obligation to either make a confiscation order in the simplest cases, or to set a confiscation timetable within 6 months from sentencing a defendant. Now, we've taken a starting point of sentencing to allow for multi-handed cases where one defendant pleads guilty many months before the trial of others. We've taken an end point of setting the timetable because from then the court is seized of the matter and able to case manage the proceedings. And we've taken a maximum period of 6 months, bearing in mind this includes the time for the application to be made, the case to be listed with all the vagaries of obtaining a listing, and for the timetable to be set. As happens now, we hope that most confiscation timetables will continue to be set on the day of conviction or sentencing. Now, this proposal does represent a tightening of the current position where, following the case of Crown against Galini, it appears that the legislation may permit 2 years to elapse between conviction and setting a timetable. We've decided against recommending a time limit on concluding confiscation proceedings, bearing in mind the problems in the past. the existing reasonable time obligation under Article 6 of the Convention, and the absence of time limits on concluding criminal trials in the Crown Court, save in relation to the starting of the first trial for defendants in custody. So let me turn then to the next slide, Chapter 7, Timetabling and Case Management. Now this chapter concerns regularising the procedure for the exchange of statements during the confiscation timetable and making those statements as useful as possible. Proposal 4 concerns prosecutors' statements. We are looking at every means available to try and reduce the incidence of unrealistic confiscation orders and promote early agreement. Might prosecutors' statements be part of the answer? At present, they're often drafted by a financial investigator with limited or no input from the prosecutor or the prosecution advocate. We suggest their format be more closely prescribed by the rules, and we are querying whether there should be a requirement, perhaps restricted to certain kinds of cases, for lawyers to have input into them. Are there cases where the first time the prosecution lawyer or advocate really considers the Section 16 statement is shortly before the case is listed for confiscation? If they were required to look at it sooner, might the case resolve sooner? Are there cases where a prosecution advocate feels bound by the way the case is presented in the Section 16 statement, which they would have presented another way had they been consulted earlier? So turning to my next slide then, Chapters 8 and 9. Well, these chapters concern further proposed procedural reforms to encourage early agreement and to formalise current best practice by introducing a formal early resolution of confiscation hearing, or an EROC hearing, and meeting, and a new form, the confiscation hearing management form. What I want to look at is what I've listed as Proposal 3 in Chapter 9, incentivising agreement. Now, encouraging the agreement of confiscation orders would seem to be desirable. Elsewhere, we recommend defendants be encouraged to submit offers to settle in their Section 17 response and at the EROC hearing and meeting. The difficult question is, what, if any, further incentives can we offer a defendant to do that? But what we recommend is that this shouldn't be done by allowing defendants to keep some funds that would otherwise be subject to a confiscation order, or by offering a reduction in their sentence to a defendant who agrees a confiscation order. Should there be some scheme similar to Part 36 offers in civil procedure? Well, one problem is that many defendants in criminal cases bear a very limited liability for their legal costs, so incentives relating to costs may not be effective. Now, another overarching connected question might be, do we need to encourage more agreement between the parties at all? We've heard evidence that at present almost all confiscation proceedings do end in agreement. Anecdotally, we've heard of judges who go 15 years without doing a contested confiscation hearing. So perhaps the issue is more, should confiscation cases be agreed earlier, and are they being agreed in the right terms? Our proposals regarding more detailed statements of information and a formalised EROC hearing are designed to further those ends, but we don't recommend a system of formal discounts or Part 36 offers to supplement those reforms. Well, turning to my next slide, Chapter 10, Forum. Now, all the proposals in this chapter are intended to address the concern expressed to us that confiscation can involve complex issues of property and commercial law, tricky for civil judges and far removed from the diet of most Crown Court work. Looking at point 3, permitting a judge to appoint an assessor. Well, an assessor would be similar to an expert, but someone who might sit with the judge and advise them. Now, at first glance, this might seem to be an anathema to criminal practitioners, but it is something already open to the High Court, Family Court, the County Court, the First Tier, and Upper Tribunals. It appears to be a step rarely taken by these courts, perhaps restricted to cases involving particularly technical evidence, for example, patents in the High Court. However, in the circumstances, and given the quasi-civil nature of confiscation proceedings, we don't see a justification for continuing to deprive the Crown Court of a similar power to that enjoyed by the courts that I've mentioned. Well, turning to point 4 on my slide, a concern expressed to us was the position where there are parallel proceedings, for example, confiscation proceedings in the Crown Court and ancillary relief proceedings relating to a divorce in the Family Court. We considered a proposal to permit, in those circumstances, 2 separate courts to sit together with potentially 2 judges and 2 sets of advocates. However, we concluded that was impractical. But what we do recommend is this more restricted reform, permitting a Crown Court judge to refer an issue to the High Court for a binding determination. Now, this is also something that we anticipate would only be rarely used. The example we give is where confiscation proceedings are ongoing and where a defendant makes a linked judicial review application. Instead of the Crown Court reaching one conclusion and the High Court potentially coming to another conclusion, we propose that the Crown Court have the power to refer the issue for a universal determination by the High Court. The power might be used more widely, for example, if there are parallel proceedings in the Crown Court for confiscation and in the High Court for a declaration of interest in property. Well, turning to my conclusion then, what next? I'll hand over to Colin and the other speakers in a moment for their views. But as Penny says, what we really want are your views with the benefit of your experience. And on this final slide, I give the links to the Law Commission page relating to confiscation, and also the 2 pages where you can respond directly to our proposals. All you need to do is put in your name, nothing else, and just answer the questions that you want to answer. All responses will assist us in our work to craft the best proposals to present to government. Thank you very much.
Thanks very much, David, for that overview. And there will be a Q&A session after the 4 responses. And if you do have any questions, please put them in the chat box, and we will put them then to the panel afterwards. So our first respondent is Fiona Jackson, who is a renowned expert in asset recovery based at 33 Chancery Lane. Fiona has expertise across the whole spectrum of POCA matters, and she has represented a wide range of prominent defence and prosecution clients. Fiona regularly delivers lectures in this area and contributes to the textbook Confiscation and the Proceeds of Crime. Fiona is appointed to both the SFO's 8 panels of Prosecution and Proceeds of Crime Council and the CPS Advocates Panel Specialist Proceeds of Crime List. Fiona is a committee member of POCLA, the Proceeds of Crime Lawyers Association, and she's a bencher of Inner Temple and Master of Outreach for the Inn. Over to you, Fiona.
Well, Colin, thank you for that fulsome welcome. Good afternoon, everybody, and thank you very much to the IALS and the Law Commission for inviting me to participate this afternoon in this discussion about the long-awaited consultation paper on reforming the proceeds of crime legislation. I'm keenly aware that some of our other panellists have a lot of ground to cover on chapters where the proposals for reform may prove more controversial. So I'm going to keep my summary and remarks brief for now, and then we can pick up any areas for debate later in the Q&A. But for those of you who haven't had time to consider Chapter 6 yet in any detail, the Law Commission accepted the invitation of the Supreme Court in Guraj to consider the best way of providing realistically for the sequencing of sentencing and confiscation and the status of the procedural requirements in the Act. Many of you may remember that before the Proceeds of Crime Act, there were all sorts of difficulties with a complex procedure to commence and postpone confiscation proceedings, very lengthy delays before defendants were sentenced often. But even with the current permitted period of postponement for up to 2 years and an extension beyond that in exceptional circumstances, there have been real problems with the current regime, including a lack of clarity in postponing or proceeding with confiscation, and confiscation proceedings are routinely subject to drift. So as David has outlined, it's proposed in the reforms, firstly, that sentencing will take place prior to confiscation proceedings being resolved unless the court otherwise directs. I think that this is a legislative steer which seems really sensible. In fact, it's generally what happens in practice now, allowing defendants to be sentenced promptly for their crimes and ensuring that any prison or other sentences are commenced promptly and effectively and proportionately, so that defendants are not waiting a very long time to decide to hear how long they're going to be sentenced to what is generally in these cases a term of imprisonment. The Law Commission's got a number of other reforms proposed, and David touched in more detail on the proposed discretion of the court to impose financial penalties and forfeiture orders prior to confiscation proceedings being resolved, and a linked proposal that where such an order is imposed at sentencing prior to resolving the confiscation proceedings, the court has to take the order into account in determining confiscation. Again, it strikes me that this is a sensible proposal for reform. It's not a mandate, but it's the discretion. And I think it will oblige the court to confront at an early stage whether it's appropriate to do so. And hopefully then it will avoid the problems of confiscation and forfeiture orders being made in error, as they were in Kakad and Sachin. It seems sensible to me in simple cases of forfeiture, for example, where there's going to be no material impact on the confiscation proceedings. But the final three proposals in this area, I think, will prove a little more controversial. You'll recall from David's overview that instead of the current system based on postponements, they're proposing instead there should be a 6-month maximum period between sentencing a defendant and setting a timetable for confiscation, or for disposing with the need for a timetable and making a confiscation order. And linked to that, they propose that the 6-month statutory maximum period can be extended in exceptional circumstances. If the 6-month period elapses, the court wouldn't be deprived of jurisdiction to impose the confiscation order, but it might choose not to make an order if it would be unfair to do so. Before declining to impose an order, the court has to consider, the Law Commission proposes, whether any unfairness could be cured by other measures. If it decides to proceed and set a timetable, the court has to actively manage the proceedings and resolve those within a reasonable time. Now, I can see that these are all intended to reduce drift, which has no doubt been stressed repeatedly to the Law Commission during its consultation process. And by not prescribing a time limit on conclusion of proceedings, the Law Commission intends the court will continue to use the existing case law as a flexible approach, it calls it, and to preserve Article 6 fair trial rights, to deal with confiscation justly. But I do have a concern that in many cases the courts are going to be open now, if this proposal is adopted, or these three proposals are adopted, to lengthy legal arguments about extending the period of time, which will then build in further delay while they're determined, unless the Law Commission makes it abundantly clear, or the parliamentary draftsman does if they're accepted, that what is proposed, as is set out in paragraph 681 onwards, is that the 6-month period is for initial financial investigation and a decision as to whether to proceed to confiscation at all, and not that the proceeding should be expected ultimately to be concluded within those 6 months. Because, of course, as many of us know, a lot of cases need time to resolve in complex domestic and often international investigations that can't be resolved speedily. But there'll be frequent arguments that those cases simply aren't exceptional. They're often routine and the norm now. So I think that we should be careful in considering these particular three proposals as to whether, in fact, they're going to produce more time lag within the system and more delay while legal arguments are resolved. So those are my initial thoughts on Chapter 6. Back to you, Colin.
Thanks very much, Fiona. Next up, we have Debbie Nocton, who is the Head of Confiscation in the National Compliance and Enforcement Service, part of HMCTS. And Debbie moved into her current role just over a year ago, but she has worked in HMCTS for 30 years and has previously managed legal teams in the Magistrates Courts and the NCES. As Head of Confiscation, Debbie is responsible for 6 regional confiscation units dispersed across England and Wales, and she leads a team of 50 administrative colleagues who are responsible for collection and enforcement of confiscation orders. And alongside her day job, Debbie has also been conducting doctoral research at the University of Lincoln about improving the enforcement of confiscation orders in the magistrates' courts. And her PhD is due to be awarded imminently. congratulations on that very impressive achievement, Debbie. And having had the chance to read this PhD in advance, I highly recommend it. Debbie, over to you.
Thanks, Colin. Well, thank you for that at the end. And may I also add my thanks to Fiona's for the invite to speak today. As Colin says, I work in HMCTS, so I am here as an official of HMCTS, and I can't reflect views of ministers or the judiciary, but what I can give is an operational context to the chapter that I'm looking at today. And as Colin says, I very much work at the end of the process in the collection and enforcement of confiscation orders, and I've been asked to look today at, or to speak today about chapter 7, which is all about timetabling and case management in the Crown Court. So you may be sitting there thinking, well, why is Debbie talking about something that happens at the start when her interest is very much at the end? But actually, what happens at the start, what happens at the Crown Court impacts very much on what happens at the end of the process. And I'm very keen, as part of this consultation, that anybody who is thinking about responding or actually responds doesn't just look at the individual chapters, doesn't look at the individual part that they're interested in, but looks at the whole and ensures that any comments take into account what happens at the collection and enforcement stage, because I do think that is very important. So chapter 7 is about the approach. It covers the approach to timetabling at the moment, any problems that arise, and just make proposals for changes. I think those who practice at the Crown Court are best placed to answer the detailed questions that are posed in the consultation. But there are a couple of operational things that struck me as I was reading the chapter. The first one is the aim of the chapter is to improve the information that gets to the judiciary and the Crown Court when they're deciding either to make a confiscation order, or when making a confiscation order, how, what form and content that confiscation order should be. And my view from an operational point of view is that anything that is done to assist the judiciary out of court, so when they have all the information, they have the information in the courtroom, anything that is done to assist them can only be of benefit. The recommendations also talk about the filing of statements in a way that's prescribed, so that information is given to the Crown Court in a timely manner to make those decisions. And again, they are things that I think the practitioners at the Crown Court would be better placed to comment on. What struck me as I was reading it and what caught my eye was the suggestion, and it's not a recommendation, but it's a suggestion, that storing the statements that are made would assist the Magistrates' Court on enforcement, so much further down the line. And when I first looked at that, I thought, yes, anything that we can get to help on enforcement would be of use, especially when you look at elsewhere in the consultation document, and the proposals are for an increase in compliance orders or contingent confiscation orders, and also the recommendations about Section 10A determinations. Then when I sort of took a step back and thought about it, I thought, well, we used to get the statements as part of the information that we got from the Crown Court. But as the information that we receive about the order itself has improved, we don't see those anymore. And we can ask for them if we need to, but I wonder in practice how often we would in the future. So one of the questions for me when I'm looking at this with my colleagues in HMCTS will be to ask that question: how often would we use the statements? I can see occasions where they would be useful. So, for example, if somebody comes to the Magistrates' Court and puts forward an argument for not paying that has been put forward and discounted at the Crown Court, I think that would be very useful for the magistrates in the courtroom. and I can see where it would be useful for other applications, for example, on a reconsideration. But the takeaway for me is to go away and to discuss with colleagues what use we would make and whether or not we would need them in all cases, or whether it is something that would be useful for us to draw on as and when we need it in particular cases. So to sum up for me, from a practical point of view, in terms of the recommendations as to how statements should be given and the timetables, I would leave that to those who practice at the Crown Court. But as I said at the start, what I would ask for is, when you look at the consultation document, don't just look at individual chapters in isolation. I think the Law Commission have done a very good job of taking us through the process and the steps that a confiscation order goes to get to the order being made. And although we come right at the end of the process, so after an order has been made and we're looking at how it can be paid and how it should be enforced, I'd ask you to consider that all the way through, including when you consider timetabling and statements and the recommendations in Chapter 7. Thank you. Thanks, Colin.
Cheers. Thanks, Debbie. And next up, we have Barnaby Hone of Drystone Chambers, who again has a wealth of experience in asset recovery and financial regulation. His practice has encompassed work throughout Europe, Africa, the Caribbean, the Americas and Asia, including providing advice to countries such as Kosovo and BVI on developing or improving their asset recovery legislation. He's a contributor to Millington and Sutherland Williams on the Proceeds of Crime Act, published by OUP. He also sits as a fee-paid tribunal judge, presiding over immigration and asylum matters. And Barnaby is also a visiting professor of practice here at the Institute. He was appointed as of the 1st of October. So I'm delighted that, Barnaby, this is your first time that we are wheeling you out as visiting professor of practice. Over to you.
Colin, thank you very much for that kind introduction. And may I add my thanks to that of Fiona and Deborah. I've been asked to discuss particularly the EROC. Now, I think the idea of a form is very good to concentrate on how we can, what the issues are, help judges understand that, and also for practitioners, that might well cut down the work we do on skeleton arguments and indeed providing lists of issues. It just formalises the process. I think the chapter also looks particularly at how we can structure that with hearings and potentially meetings. I don't think a meeting would potentially help if there is no legal aid to pay for it. Often the meetings and hearings are farmed out to other counsel because trial counsel are busy or the final counsel are busy. And without those counsel, that's why we often get an issue with who does the final hearing and when the final judgment and often conclusion is made. So I think we need to look at that process. Funding is something the Law Commission can't look at, and though of course there can be hints and proposals, I would recommend that we look at combining both the discussion and the hearing, which is in essence a formalised directions hearing, together. Allow a process such as that takes place in sex cases to concentrate on the issues. I agree with the Law Commission that we can't have a judge doing something as we do in the family courts with actually deciding the issues, because it could be very difficult and it could rule them out of a final hearing. But I think that mechanism to decide and to concentrate on the issues could be useful, and a form could be a good catalyst for that. There has been discussions about, in the Law Commission's work, about how decisions and agreements come together. Often they're on the door of court, and there's discussions of whether they're pragmatic rather than legally based. From my experience, They are mostly legally based, but also looking at the wider public interest and take into account lots of different court users and stakeholders' viewpoints. But they also need to concentrate in those circumstances on counsel's views a lot of the time and on the practicalities of the court time and the balance between that and the agreement. So I understand why the Law Commission has talked about financial investigators feeling left out from time to time. They shouldn't be. But there should also be a change in attitude potentially. We talked about defendants looking at being more engaged, but also prosecutors potentially looking at how an agreement can be reached. Sometimes there can't be, and that should be accepted. And also not just leaving the matter to the court. I've heard that phrase twice from prosecutors in the last month. That I don't think should be an attitude. And when I look at recommendations, one of the ones that comes to mind for me is to put in place more mechanisms to assist an agreement. I don't think the Part 36 agreement would work. As mentioned by David, costs are not an issue because in most of cases, costs are paid by a defendant and often all their assets will go, so there won't be an order to costs. There has been mention in the chat and the question and answers about CPIH. In practice, I can understand why that might be a factor which is mentioned, but in practice, that is not a huge factor because it affects the benefit, and often the available amount and the benefit are very wide apart. It might affect much bigger cases and some smaller cases, but I don't think it would be an overall factor that defendants would consider. It also then meets on the public interest issue of going against CPIH, my apologies, and the idea that we're not gaining the full benefit of the criminal activity. But I want to go back to one principle. If we look at agreements and how agreements are reached and what type of agreements, one of the incentives for the prosecutor is to make enforcement easier. This is highlighted very well in the Law Commission report. And what I would suggest is that formalised processes, such as paying money into court by defendants over a period of 3 months while the matter is adjourned to a final hearing, and formal mechanisms such as that could be encompassed in legislation, so that rather than going to a full hearing, it is agreed that a benefit and available amount will be put in place only if certain assets are realised by X date and that money is paid in. This will allow the enforcement period to, in essence, be null and void and take that out, which is a very difficult part of confiscation. It's only a suggestion. It's something which might want to be considered, but that might be an incentive for both prosecution and defence to engage. And if you have the process, it will be something which would become potentially more common. So it's putting in processes which are tools which parties can use. But I'm very grateful for the opportunity to speak, and I look forward to be part of the question and answer session.
Thanks very much, Barnaby. And our next respondent is Mujahir Ahmed, who is a solicitor advocate in the Criminal Law Department at Thompson & Co. Solicitors. He regularly undertakes high-profile criminal cases, many of which attract media attention. He has represented clients charged with a range of serious criminal offences and has significant expertise of engaging with confiscation matters, both involving lengthy, complex proceedings and or in negotiating a resolution with authorities where appropriate. Over to you, Mujahir.
Thank you, Colin. Thanks for inviting me to this webinar. It's been very useful, and thank you for the earlier 3 speakers. They have shared really good points. I have been asked to comment on Chapter 10, which is forum in this consultation paper. And I would go straight to the proposals mentioned in this consultation. It has been very significantly delayed, I must say, but better late than never. Our current POCA proceedings are very old, even though they only start in 2002. But the Act is so difficult to understand even for the judges. It did need consultation and changes. Now, the three proposals are mainly with regards to why the judges in the Crown Court have to deal with matters that overlap with civil and family proceedings, and not just simple family and civil proceedings, but of complex nature. And that is why there has been significant case law and a number of cases which were decided incorrectly on the face of law at first instance in the Crown Courts. Some examples are where cases are decided by wrongly interpreting the criminal lifestyle or not considering properly the family and civil overlap of the jurisdictions. The first proposal is to have ticket judges to deal with confiscation proceedings. It's a very good idea. I totally agree with that. The problem with that idea is, one, there might not be enough ticket judges to deal with all matters, and often seem where there are complex confiscation proceedings involved, they follow a lengthy and complex fraud or likewise drugs trial. And it may be that the intention behind this is to have every judge of such nature have a ticket to deal with confiscation proceedings. But if that's not the case, then a trial of very significant length will come to an end. A confiscation proceedings will commence in front of a different judge, and the assessment of the evidence will have to start again. The idea that the trial judge would continue with confiscation is far easier and manageable. So whilst considering a ticket confiscation judge is a very attractive idea, a pool of judges that would be able to do that will have to be considered significantly, because the Crown Court judges are under immense pressure to deal with overload of cases, and in the current crime rate, we have a lot of outstanding cases that have not even started. The second proposal is to have an expert assessor, which David spoke earlier today. Again, a very good idea to have an expert assessor to consider the proceedings from the outset and give a rather independent assessment of the assets. And that has to be considered where these assessors will have to consider the defense put forward at the trial, the elements of the assets where there is third-party interest is involved, and also to consider the legal issues which are not related to criminal law, considering from civil law and more likely matrimonial law issues where there is a non-criminal spouse involved and their interest needs to be considered significantly. What is the most attractive proposal I have seen here is referring the confiscation proceedings to High Court, again mentioned by David earlier today. What that would do, in my eyes, the complex proceedings where interest of non-defendants involved, like spouses, current or ex-spouses, children of the defendant, and any other third party, that would take the matter away from Crown Court judge, take it to the High Court judge, where decisions will be binding and the matters of law will be considered in great significance. The only issue with that proposal is how the parties would be funded. Barnaby has touched upon the cost implications for lawyers as well. Some cases involve confiscation proceedings have lawyers on public funding. Going into the High Court, that public funding stops. Whether the public funding would be available, that is a matter of a separate consultation, I take it, but that something needs to be considered when providing these jurisdictions to the High Court. Those are my points. Thank you very much, Dave. Colin, again, over to you.
And that leaves me to thank all of our speakers for some fascinating insights into POCA and the challenges that it poses in practice, and certainly the challenges for the Commission in formulating their final report in this area. Thanks to the Law Commission for engaging with this process, for collaborating with us in IALS, and for asking us to host this webinar, and to our participants for very interesting questions. And can I remind everyone again, please do engage with the consultation process. I know that is something that the Law Commission is very keen to stress. It's not just a case of being here on the webinar, posing a question. Please send that to the Law Commission. David, I pass over to you for any final closing comments.
Finally, just Colin, just to say thank you very much to you and to the IALS for hosting us, and to echo your thanks to all the other panelists for giving up the time and giving us the benefit of their expertise, and thanks to everyone for coming along today, posing very intelligent questions and attending the event. We're very, very grateful.